Can you prove your medical malpractice or accident case simply by showing that the people you have sued are lying? You want to know the answer? Come join me for a walk around the neighborhood as I walk my dogs, as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The short answer is no. You cannot prove your medical malpractice or accident case simply by showing that the doctor or the person who hit you or the person who's responsible for your injuries is a liar. That is insufficient in order for you to prove your case. Now, what's all this about? I'll tell you what it's about. Many people think that just because the people that they are suing is a liar, or being less than truthful, or incapable of telling the truth, or doesn't know the difference about telling the truth, or their version of the events is so diametrically and so different from what their version of the events are, now they think that that's sufficient to go ahead and show to the jury that they should be entitled to a verdict in their favor. Well, I'm going to share something with you that nobody talks about. The reality is, that's not how it works. That's not how it works at all. And you might be wondering, okay, how does it work? Well, I'm glad you asked. Here's how it works. If you bring a lawsuit against your careless doctor, claiming that he was careless and caused you significant harm and injury, it is you, the injured patient, us, as your attorney, who have an absolute obligation to show that we are slightly more likely right than wrong, that what we are claiming is true. Now, what does that mean? That's our obligation. It means we have to put on proof. We have to show evidence to show that we are slightly more likely right than wrong, than what we are claiming is true. And how do we do that? We do that by using the medical records. We use that by using evidence such as photographs, eyewitnesses who have told us exactly what they observed in order to show that our version of the events is more likely true than not true. That is what we need to do. Which means you, as the patient, for example, in a medical malpractice case, you will need to go ahead and explain and testify in your own words exactly what occurred to you. Now, there will be other witnesses as well. Maybe your spouse is a witness. Maybe there's some other witnesses. Maybe even there are some doctors or nurses or other people who are involved in your care who can also testify to certain facts. And now we use all of those facts and the medical records and any other evidence that we feel will be able to support our claim that what we are claiming is more likely true than not true. We cannot go into court and simply show the contradictions between what you have said and what your doctor has said. That is insufficient to show that we have a valid case. Now, how is it that we can hire medical experts to then testify in our behalf? I'll tell you why. Because you and the doctors and the medical records establish the facts as they are. We can now have medical experts review those facts and give us their opinions and interpretations of what those facts show and, importantly, what they mean. That is how we go ahead and show that we are slightly more likely right than wrong, that what we are claiming is true. If you intend to rely solely on a he said, she said scenario, where your version of the events are totally different than what the doctor has said or what the other person whom you have sued has said, that is not going to be sufficient to go ahead and prove a case on your behalf. That will address credibility. And credibility is always an issue in these cases involving medical malpractice, involving accident cases, involving wrongful death. Credibility will always play a part in that role. However, credibility is never going to be enough in order to go ahead and prove, to show that we are slightly more likely right than wrong. That is a critical difference to understand as you're trying to decide whether or not you need to go ahead and bring a lawsuit on your own behalf, trying to obtain money as a form of compensation for all the harms, losses, and damages you suffered because of someone else's carelessness. You know, it's a distinction that no one really thinks about until you're deep in the middle of what we call discovery, trying to learn all the facts in the case. I'll tell you how we do learn the facts of your case. You come to us, and now we have to evaluate whether or not you have a valid case. We sit down with you and try and learn all the details of what happened to you. But then, we now have to verify that everything you've told us is correct. And we have to go ahead and get all of your medical records in order to piece together to try and determine, from a medical standpoint, whether what you have told us is accurate and correct. Then we have to get additional medical records. And then we have to have our expert review those records in order to confirm and back up all of those facts. If our expert does confirm that you have a valid basis for a case, great, now we go forward. During the course of the lawsuit, we will have an opportunity to question the various doctors and people whom you have sued. And I will have a chance to question them under oath, to learn from them what their version of the events were and what they believe occurred. Many times we will find that their version of the events are totally contradictory to our version of the events. So now you might think, wait a second, how do we prove our case if their version of the events is totally different than our version? You claim that you told the doctor a specific complaint on this particular visit. The doctor denies that you did that. You claim on another visit that you told the doctor again something critically important. The doctor denies that you ever did that. The doctor says that if you had done that, he would have written a detailed note explaining that because that was a very important point. So you believe that just because your version of the events in your heart of heart is correct and the doctor's version is not, that you can go ahead and you'll be able to prove your case and come out smelling like roses, and you'll be successful if your case goes to trial. Well, you may ultimately be successful, but it may not be because you're able to show the contradictions between what you had to say and what the doctor had to say. Rather, what may come about is that you may be successful because, on your own merits, through your version of the facts and all the other supporting witnesses and the supporting evidence, you are able to show that you are slightly more likely right than wrong, and importantly, that the jury sees it that way. So why do I share this quick information? I share it with you just to give you an understanding of what really happens in these medical malpractice cases, these accident cases, and these wrongful death cases here in the state of New York. You know, I realize you're watching this video because you wanted to see my dogs. No, I know you didn't want to just see the dogs, and here they are. Bentley is the black one here. Daisy is the light brown one right here, and they are enjoying their walk right now. No, I know you're not watching this video because you wanted to see my dogs as I'm walking them today. You probably have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit and are thinking of doing so, but still have questions that need to be answered, what I invite you to do is, you know what I'm going to say, right? Pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a fantastic day.